Preparing and Presenting Evidence in Court, and this is SEC3124. Now, possibly certainly nominated by Paul and I as the greatest video ever made, I'm about to show you, okay? So everybody, get ready. Some of you may have seen this. Certainly the older people from the 80s would have seen it, 80s and 90s. Anyway, here we go.
I swear
the evidence I shall give,
that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth and nothing but the truth.
The whole truth and nothing but the truth and that.
Proceed, Mr. Rogers.
Thank you, Your Honour. Mr. Carpenter.
No, that's,
You are Mr. Carpenter?
No, that's my dad. He left when I was a little baby. He had something important to do.
Is your full name Colin Joy Carpenter? Is it?
Yeah.
Right. Mr. Carpenter, can you tell us what happened on Thursday the 16th of February?
Yeah, right. Well, I got up around about 10 o'clock. No, tell a lie. It was past, and I was really hungry, so I had some Cocoa Pops.
Cocoa Pops?
A type of breakfast cereal, Your Worship.
Yeah, just like a chocolate milkshake, only crunchy.
Is this relevant, Mr. Rogers?
No, Your Honour. Mr. Carpenter, could you turn your attention to what happened after breakfast?
I washed my plate and spoon.
After that, Mr. Carpenter, did you go anywhere?
Yes.
Where did you go?
To the toilet.
No, Mr. Carpenter, did you go outside the house?
No, the toilet's on the inside.
Mr. Carpenter, if you could focus your mind, did you leave the premises?
Yeah. I went down the bank because it was dole day, and I had to take down some dole checks to cash, of which there was only one.
While you were in the bank, did you notice anyone unusual?
Yeah, there was this guy who's bald, right, and he'd swooped his hair, like, right over the ball bit, but the wind had caught it, and it was flying up there so you could see this bald streak.
Did you notice any customers that were unusual, wearing unusual clothing?
No.
No one?
No.
Mr. Carpenter, in your affidavit, did you not swear that you saw a man wearing a balaclava?
Yeah.
And carrying a sawn-off shotgun? Well, wouldn't you say that was unusual?
Not for a bank robber.
Mr. Carpenter, it's not up to you to decide whether or not he was a bank robber. Just tell us what you saw.
Sorry, Your Highness. I saw a guy in a balaclava.
And what was he doing?
He was robbing the bank.
Can you tell us what you did after you saw the man robbing the bank?
Well, I immediately, sussed out what was going on and managed to thwart the escape attempt of his accompanist, who was cleverly disguised at the time as a policeman.
I put it to you, Mr. Carpenter, that he was a policeman who was trying to apprehend the accused.
Yeah, I know that now.
And you tripped him up.
Yeah. No, I was just trying to be like a law-abiding citizen, you know. I was just trying to do the right thing.
Your Honour, I think perhaps we could break for lunch.
Well, I've met him twice, that's all. I don't know him.
Mr. Carpenter, order, please. Order.
I'll have a salad sandwich, a bit on a slice.
Okay, great video. A bit of fun there. Colin, Those will remember Colin from the comedy company days. Okay, so this is about preparing evidence, okay, and giving evidence in court. So just a bit of an indication, online and the fellows here in class, you're given evidence in court in your job or as a private capacity. So if you haven't, what you may not know is it actually is quite a daunting experience, and because courts are very formal places, there's lots of people like with wigs running around and gowns and talking silly, and you've got to keep quiet and you can't wear your sunglasses and all this sort of stuff. So it is a very formal environment, so you need to at least be familiar, I guess, with what a court looks like and who sits where. We all know that the judge or magistrate generally sits up the top, sometimes wears a wig, that sort of thing. I'll give you a couple of little key things along the way this morning. Just etiquette, they call it, I guess. Things to do and not to do, particularly in court. And again, if you're a professional investigator, your appearance matters, because what does matter when you go into court and give evidence is, that old saying, "Don't judge a book by its cover." Well, guess what? It's exactly when you are judged when you go to court, the way you give evidence and how you present yourself. So, as an investigator, I wouldn't expect you ever to turn up to court in jeans and a pair of thongs and an old shirt. Okay, you dress appropriately, because that's the image you're giving. You're saying, look, I'm a professional. The evidence I'm giving is credible, reliable and professional, so it should be believed. And that's whether you're giving court on your own or whether you're giving evidence on behalf of the company you're working for or the client you're working for, whatever it is. It may not be necessarily a criminal matter, it could be a civil matter as well. Okay, so preparing evidence, and just I guess the other thing to keep in mind is this is a bit about preparing things like briefs of evidence. Doubt you would ever do as a private investigator. However, if you go into the government area where you are investigating things, you may have to prepare briefs of evidence. So if that's a route that you're going to go down, well, you probably need to know a bit of this stuff as well. So a lot of it may be a bit irrelevant, but in any case, you need to know it. So again, let's look at workplace policies and procedures to ensure compliance with legal rights. Wow, have we heard this before? About 100 times during this course. Again, it's about complying with policies and procedures of the organisation that you're working for. In this case, it's about preparing evidence. So reviewing work instructions, policies and procedures and legislation, and the things that are going to impact are those things like the Code of Conduct, Health and Safety, Policy and Procedure. Other things, obviously the Privacy Act. Paul mentioned the other day things like the Evidence Act, and you don't need to know that back to front, just know it exists. You've learned a little bit about evidence during this course. We should know, should we not, the two things that makes the two types of evidence. It must be admissible and relevant. Okay, so we have talked a little bit about what makes evidence admissible, and you'll remember we had that conversation about inadmissible evidence, evidence obtained improperly or illegally, stuff like that. And you should know things about Surveillance Devices Act. You should know a bit about the legislation you work under as a private investigator, so that'll be different for all states. So again, this is not the thing you need to know back to front, every section, every subsection and that sort of thing, but know the where you get your powers as a private investigator, know what act gives you those powers. Because there's nothing worse than sitting in a witness box, and what you'll probably get asked, and this is what particularly other defence lawyers and stuff will try and trick you up on, is that, well, tell me, Mr. or Mrs. whoever, where do you get your power to be a private investigator? If you don't know the answer to that, you would look pretty silly, wouldn't you? So at least know that. You don't need to know every section of it, but at least know that. Okay, so when you're doing final reports or putting together briefs of evidence or preparing to give evidence in court, very important that you review all the information that's been gathered. If you made a statement in relation to the matter, know it. You do not need to know it word by word. You don't need to memorise things for court. You'll remember when we did note taking that you will, of course, always take your notebook to court with you, And if you can't remember something, you will ask the court if you can refresh your memory using the notes. I hope that that's one thing you did take out of the note-taking exercise. So know your statement, because you don't want to be tripped up on that either. You don't want to contradict. You don't want to give the evidence in court in the witness box that contradicts what your statement says. So be familiar with it. Also check on any evidence gathered. If there are any exhibits that you're presenting, make sure you take those original exhibits with you. Make sure that you can prove that the chain of evidence has not been broken. This is where it all counts in the end. Okay. Compiling a brief of evidence, again, unlikely you would have to do that in a private capacity, but if you do, well, the briefs of evidence are sort of a whole new beast, whereas you gather all the statements, gather all the evidence, annexures, and put them together, typically to be served on the other side. Okay, we've talked about rules of evidence must be relevant, must be collected in a way that makes them admissible. We've already discussed that. Organising your evidence. So evidence management, generally during your investigation, not sure what this has exactly got to do with giving evidence, Paul, but here we go, is reviewing your evidence continually during the investigation. We've talked about the chain of evidence. Simple things you need to think of, like labelling. Okay, so is that the same label? If you have an exhibit and it was packaged, is the seal that you packaged it the same as what you are presenting to court? You know, simple things to think of as an investigator in the chain of evidence is that if you seal something, sign across it. Okay, if that sign is broken, well, somebody's accessed it. So you just need to be able to show that sort of stuff when you're presenting evidence. How have you stored it and things like that. Obviously, you know, if you've got a piece of evidence that's a car, you don't need to take a car to court, but photographs and documents are sufficient. Now, evidence in court is normally presented to all parties as a brief of evidence. Again, not going to talk too much about a brief of evidence, but it's like a report. So, brief of evidence may contain your report, may contain your statements from any complainants or witnesses, may contain a transcript of an interview you might have done with somebody, photographs, measurements, maps, whatever, okay, can go into a brief of evidence. And they're normally fairly generic, but again, you'd be guided by the policy and procedure of whoever you're working for to put those together. Okay, so preparing for court proceedings, there's a lot to sort of, you know, familiarise yourself with in relation to what a court looks like. And again, if you haven't been in one, walking in one is quite, I would say scary. It is a little bit scary. Would you agree that, yeah, even people that have been to court a few times, it's like walking into them, they're daunting places, you know. Sorry? Intimidating? Yeah, good point. They are. I mean, once you've been in one a couple of hundred times, it's pretty easy to wander in and you know the protocol. But, you know, I've done courses where I've had students who I've been through this sort of thing, simple things like don't wear your sunglasses on your head, okay? One of my students, what do you think happens? Wears the sunglasses on the head, the sheriff comes and taps him on the shoulder and get him off, you know. Now, there's a different standard for you as an investigator to, you can go over to the court over the road here and see the people that are on trial. There seems to be a bit of a different standard. They sort of do whatever they want, but don't worry about that. This is about you and your professionalism. That's what I'm saying. So make sure you present well. Make sure you, simple things like your shirt's ironed and you've had a shave and, well, unless you're growing a beard or something, but you know, your hair's nice and you present well, because that's what it's all about. We'll show you a couple of videos. Now, these are New South Wales videos. They're generic in terms of just to show you what it looks like in terms of court. They're not some of them are criminal. They're not necessarily relevant to you, but they may give you a bit of an idea.
Before going to court, it is important to read your police statement to refresh your memory. The judge and jury will not have a copy of your police statement and need to hear all the details from you in court. Depending on where your matter is heard, you may meet the prosecutor at a pre-trial conference. This is your chance to discuss the case, ask questions, and talk about any of your concerns. It's important to remember that charges can be withdrawn or negotiated at this or any other stage throughout the legal process. This will be a decision made by the prosecutors in consultation with you.
Stick to what you know and always tell the truth. And if you get upset, don't worry, you can ask for a break.
Try to remember the details of the incident, such as dates, times, descriptions, actions, and the exact words used in conversations. It is also important to remember that what you have to say is only part of the whole case against the accused. Remember, the prosecutor represents the community and is not your lawyer. It is their job to prosecute the accused on behalf of the state of New South Wales. Your job is to simply tell the truth. And so you will be asked to swear an oath or affirmation, promising this once you get to court.
Is that when I have to swear on the Bible? I myself, I'm not religious, so is there any other way I can take an oath?
Well, you could choose to make what we call an affirmation, where you promise to tell the truth. So you'll be told what to say and when to say when you enter the witness box.
Okay, so we've got a couple of those videos. Again, they are quite generic in nature, but they just give you a bit of an idea. And Paul, I did see a couple of questions there. Do you want to fire them at me? No?
Okay, we do have someone asking, are you allowed to go and watch court proceedings?
Yes, absolutely. Well, yes is the answer, and yes, you should. Paul would have got to that. You should go into court and watch what's going on, whether it's, it can be criminal court, can be call over, if you can find a trial with a jury, that'd be really good too. Well, you can, no. But there's one exception. Sometimes the court will be closed. So in some domestic violence matters, the judge will close the court, which means you can't go in and out. And children's matters too, you can't go in and out, and other matters where the courts may be closed. But certainly go to your local courthouse, and courts are open public places, okay? So you can go in and out and observe, and as an investigator, you probably should do that. And you learn an awful lot by doing that anyway, just to see who's who, who's talking, what it's about, how the proceedings go, how people give evidence. Some of you may have been on juries, which is great. You only hear some of the stuff when you're on a jury. There's a lot of stuff you don't hear. So by all means, yes, go to court, go in and out, try some different types of court. Tribunals, like here in Queensland, we've got QCAT, if you can observe them as well. Tribunals like QCAT and the Industrial Relations Commission are still, they're tribunals, and they're like courts, but they're a little less formal. Okay, and the evidence rules are a little different. But good question, by all means, yes, do that, and I encourage you to do that. Anything else, Paul? Okay. All right, so this unit also asks you to show competency in participating in an oral briefing session with relevant persons to confirm court arrangements, your own role and involvement. You will do that typically in consultation with whoever you're working for, okay, if you ever have to go to court. So relevant persons you may need to brief, obviously your client, any witnesses, your colleagues, police if you're working with them in some way, or if you're involved in a matter, you may get called to court. And this may happen to you as an investigator, where you've done something or seen something, taken statements or whatever. You may get called to court as a witness, so it may not be your matter. The cops may call you there. Or the defence too, that may happen as well. So same things apply. You may have to liaise with the police or the defence or management or other judicial people. There's lots of people floating around in courts. We've got sheriffs, we've got bailiffs, we've got judges' associates, and corrective services come in and out, bringing prisoners. There's cops running around, there's lawyers, there's all sorts of people. It seems like a really busy place, but it works. Okay. Discussing information to be presented as evidence and clarifying negotiation parameters. Wow. Okay, so when briefing relevant parties like those parties that I just spoke about, it's about discussing the relevance of your evidence. Now that is not discussing the evidence you're going to give. We don't do that, okay? The lawyers, police, nobody will discuss the evidence you're going to give. If anybody's had any dealings with Director of Public Director of Public Prosecutions, DPP, they often conference with you about the sort of evidence you're going to give, but not the evidence that you're going to give. So that's important too. And if you've got any other witnesses, do not discuss with them, you know, until it's over, of course, the evidence that you're going to give. Briefs of evidence. So part of your competency for this unit is to submit a brief of evidence, which seems a bit silly because, I mean, it's not really related to someone doing Certificate 3, I wouldn't have thought. But as I said to you before, what a brief of evidence is simple. It's like a little book of all the evidence you've got, your statements, witness statements, photographs, transcripts, annexed and put together in a nice little package. Description of the evidence, relevance of the evidence, etc., continuity. Again, you know, you've got an exhibit in your brief of evidence you need to prove, or you should prove that it's the chain hasn't been broken. Thorough review of material to be used in court proceedings. Okay, as a lead investigator, and this is more in line with if you're an investigator in, say, a government department or something and you're doing prosecutions. It's your responsibility to know your brief of evidence, okay, and as I said to you before, it's your responsibility to know your statement and what's in it. What defence lawyers will typically try and do is, I say trip you up in inverted commas. That's not what it's about, by the way, but they are testing your evidence. So your reliability, credibility as a witness means you need to know your statement, know your notes and that sort of thing. Not verbatim, by the way. Before submitting any brief of evidence, of course, check. So like your investigative reports, you don't want to have spelling, grammar mistakes in your brief of evidence. That just makes you look bad. You know, certainly as an investigator in government doing prosecutions, or if you're a police officer or a detective or whatever, your brief of evidence is really, it's apart from giving the actual evidence, is the end game for you. So how that is presented and in a logical, simple, good form is shows what sort of investigator you are. Chronological order, that goes without saying, and confirm that all the evidence that's in your brief of evidence is there and can be presented. So if you've got any original documents, so let's say for example you might have a receipt you took from somebody which you've, you know, packaged up and secured until the day of court, you take that with you, okay, the original. Or even though a copy of it may be in your brief of evidence, you take the original documents or original exhibits with you. It's sometimes necessary to contact the court where the matter is going to be able to hear to confirm what technology is available. Again, look, don't worry too much about this. There's lots of technology in court these days. Certainly, it was very interesting over the past 12 months how courts ran because of COVID. There was a lot of this stuff happening with Zoom. With kids matters, like kids are able to give evidence in other rooms. Domestic violence matters, they're able to give evidence so they don't have to look at the perpetrator, that sort of thing. There's lots of technology you just need to be aware of. You know, I guess people give evidence from jails and that's via video conference and that sort of thing. Don't get caught up on just know that it exists. Physical items should not pose a problem, but digital items like videos need to be saved. So again, have a think about if you're going to give evidence and say, for example, you have to play a video, which you've maybe burnt onto a DVD. Just make sure with the court that they will have, but arrangements to play that. You know, they will play it up onto a screen and the judge will see it and everyone else will see it too. So don't sort of get found wanting when you get to court and go, oh, I've got this, I didn't check. You know, do you have a player to do it? Is there audio? All that sort of thing. Okay, attending court proceedings and actually presenting evidence. So this is something difficult for me to talk too much. You really need to go to a court and have a look at this yourself. But we've got a couple of videos here.
So have you read through your statement?
Yep, I think I remember it all, but I'm a bit nervous.
Yeah, that's normal. Remember, as the witness, you're there to explain what happened as you saw it. All you can talk about is what you know. So try to think of, you know, what you saw, what you heard, how you felt, and what you did.
Okay, that helps. Any other tips?
Yeah, sure. When you go into the courtroom, you might feel a bit awkward. Remember to listen carefully to the questions that are being asked. Speak clearly so that the court can hear you properly. And if you don't know the answer to a question, just say so. If they ask you a question and you need them to re-ask it, don't be afraid to do so, and they'll rephrase it for you. Also, take a couple of deep breaths before you go into the witness box. It, helps to calm the nerves down.
I think I'm ready. When are we on?
Yeah, we're on at 10 o'clock today. Why don't you go and sit in the public gallery and you can get a feel for what's happening in the court today.
Okay.
Cases in the local court are heard by a magistrate rather than by a judge and jury. The magistrate will determine the matter and may impose a sentence if the accused is found guilty. If the case is more serious, the magistrate will decide if the case should be committed to the district or Supreme Courts to be heard before a judge and possibly a jury. This is called a committal hearing. Most likely you won't be asked to attend a committal hearing, but you may choose to go along and see how the court process works. And whilst it is possible you might be called to give evidence at the committal hearing, this is generally not the case.
Remanded in custody.
Thank you.
Given the serious nature of this offence, bail is refused and the accused shall remain in custody pending the case being heard in the Supreme Court.
Local courts can be busy, crowded places and often feel quite chaotic. Lists outside the courtroom have information about your case and tell you what court to go to. Multiple cases may be heard in a day and decisions are often made swiftly. It can be important to have a support person with you to help you get through the day. Regardless of which court you're in, the courtroom is a formal place and there are a few rules to obey. Dress appropriately and in a way that shows respect to the court. Take off your cap, hat or sunglasses. Sometimes courts can be air-conditioned, so it's a good idea to bring a jacket with you. Switch off your mobile phone. People entering or leaving the courtroom should bow towards a magistrate or judge as a mark of respect for the court. Some cases will be finalised in the local court and you may be called to give evidence during the hearing process. If your case is set to be heard in a higher court, then your journey through the criminal justice system will continue on another day. The legal process can take a long time and you may have to wait for some months for your next date. If your case is finalised, this will be the end of your justice journey.
So yeah, look, a little few general things about court there. Look, fire through any questions. Don't claim to be any expert, certainly not a lawyer either, but I've been in plenty of courtrooms in my life. Fire through any questions you have about etiquette. It's hard for me to go through all the etiquette and what you should and shouldn't do and who's who in the zoo and that sort of thing. So, please, if you've got a question in your mind, fire through. It won't be silly. There are no silly questions. All right, so attending the court, adhering to court procedures and protocols. Now, I've talked about personal presentation, manner and language, okay? Very important. People will judge you by the way you look. That's not fair, I know, but it's a courtroom. As soon as you walk in as a witness, and if you've ever been a witness in a court, I know the fellows here would have been for sure, the moment you open that door and bow to the coat of arms, all eyes are on you, okay? And everybody's judging you by the way you look, whether that's right or not. Furthermore, when you go and you'll go and ask to give what's called an oath or affirmation. So I'm not sure, this may be a short answer question, I'm not sure, but an oath is something on a religious text that you take the Bible, Quran, whatever, in your hand and swear by Almighty God that the evidence you'll give be the truth, the whole truth, nothing but the truth. Say help me God. Or an affirmation is the same thing, but just without the religious connotation. So you'll be asked to do that. And what's probably one of the scariest things, and if anybody's been in court, the scariest thing is when you actually do that, because before they do that, they say, all silent, and the whole court goes silent and everybody's looking at you. Now, if you've got a packed courtroom, that's pretty scary. And why? Because you're there to tell the truth, okay? And you're holding this Bible or whatever in your hand and you're saying, yes, I am going to tell the truth according to God or just because I want to tell the truth. So that can be really scary, but once you've done it a few times, you'll be fine. Did you find that? Is that your experience?
Yeah, very much.
Yeah. So, I mean, there's a reason for that, if I remember, I'll try and chuck in a little tips for you. When you're taking that oath or affirmation, I'll just give you an example. Say this is the Bible, and I'm taking the oath, and the judge is there. I'm in the witness box, and when I'm taking the oath and saying yes, I do, or so help me God, look at the judge. Okay, when you look the judge in the eye, so that judge knows I'm here to tell the truth, judge. You know, don't yes, no, yes, I do type thing. Just doesn't look good. So a little tip there. And similarly with your answers that you're giving in evidence, I'll talk about in a minute, look at the judge or jury if there is one and give them. Don't get into an argument with the prosecutor or the defence lawyer. They're just doing their job. You're there to give your evidence to the court, not to any one person, not even to the judge, to, you know, Lady Justice, I guess. So just, again, make sure your presentation, you know, don't wear caps, take your sunglasses off, make sure you're nicely presented. Certain formalities. So we'll talk about these. So when you go into a courtroom, and you'll notice this when you go and have a look, you bow. So who are you bowing to? You're not bowing to the judge. You're bowing to the coat of arms. So it's respect for the justice system. So I hope you can all see me, but you walk into a court and you just do a bow. It doesn't have to be this grand, you know, Your Highness type thing like Colin. It's just a simple bow like that, and that's to show respect. And I say, do you have to do it? No. Go to court and see how many people don't do it. Walk in chewing gum, just haven't had a smoke out the front, haven't shaved. They're normally the people in trouble. Does anybody pull them up? No, they don't. Remember, this is about you as a professional investigator. You're going to walk in and give evidence. You know, do that. So short bow on the way in. Also on the way out, a short bow as well. Okay. Wearing smart dress attire. It's okay. You don't have to suit up these days. I mean, hardly anyone wears a suit. You know, for the ladies, I can't really comment, but wear something, you know, respectful below the knees, I would say. Sunglasses on the face, don't. They seem to really not like that, and I've seen them pick it up. I don't know why. I don't think it's a big deal, but there you go. Use appropriate language, so you would anyway as a professional investigator. Being punctual and referring to the authority as not Your Highness, but Your Honour. Yeah, in the old days, they had all these different names. Your Worship, depending on where they were, and so it's just blanket now, Your Honour. Or Sir or Ma'am, that's fine. It's about respect, okay? Presenting evidence in clear, concise, ambiguous manner. Again, it's very hard for us to assess your capability in this area without actually seeing you give evidence. But you need to, I guess, be aware that you know, you're on show. So a couple of little things. When giving evidence generally, the prosecution case, and again, I'm not that familiar with civil matters. I'm not a lawyer, and I've been involved in very few civil matters. We can only talk from a criminal context, but the case is given where all witnesses will give their evidence, and then once a witness gives evidence, they're able to be what's called cross-examined. So in a criminal matter, that's by the defence lawyer. So you can't just give evidence and not be cross-examined. You've got to remember too, and this is very important, that being cross-examined will feel like it's a personal attack on you. Okay, it is not an attack. All that person, defence lawyers, is doing their job. Which then doing their job means they're testing your evidence. That's the job for their client. Okay, so that's how it works. Once the cross-examination is given, then there's re-examination of anything that may have come up during cross-examination. That's typically how it works. But again, you need to watch these things in practice in a court, you know, to have a better understanding. So you'll not be able to read your statement out. So you may have made a statement, for example, which is fine. You won't be able to sit there and read it out, okay, even though it's your statement and you made it and it's truthful and all that. What will happen is you will be guided through that evidence by whoever's, you know, asking you to present the evidence. And, you know, they're not supposed to lead you, but, you know, generally, and you'll see this when you go to court, is that they do actually sort of lead you through. So, Mr. Smith, you're an investigator for, all Aussie investigator, yes. And you've been, investigating matters for 2 years, yes, that's right. And on such and such a day you went to such and such a place, yes, that's right. So they will actually lead you through it. Then they'll probably say, well, tell me what happened. And in your own words, you would go through in a chronological manner what you saw and did and everything. And that should fit up with your statement. That's why you need to read it. Yeah, that's right. So if your memory is exhausted, like this could have happened a couple of years ago, you might have investigated a traffic accident. You're not going to remember that. You've done 3,000 different jobs since then. So this is why notes are important, because you'd have your notebook, I'd hope, from that. And look, if you can't answer something, you just say, look, I can't remember. I just simply can't remember. I do, however, have my notebook, and you seek the leave of the court to maybe refresh your notes. But you would have done that, I'd hope, before you go to court. With your notebook? Yeah, absolutely. Have it with you, pull it out. Yeah, that's right. And saying, according to my notes, and that notebook could be tendered as an exhibit, who knows. Makes you look like what you're talking about? Yeah, that's right. Yeah, it's professional. That's why importance of good notes and having a notebook is really important. So, yeah, you'll be led through your statement, and of course you would have read it before. In the old days, I'm talking about cops particularly, they had to memorise their statements, and they did. And it's sort of a bit ridiculous because you're just up there memorising something. You don't have to do that anymore. You don't have to memorise it, just know the content of it. And again, if you don't remember something or you can't recall, just say that, don't make it up, okay? Don't feel the need to answer a question. You'll get asked lots of different questions, some of them yes, no, some of them leading, some of them to try and trick you up. Just remember, it's not actually to trick you up, it's testing your evidence. So unless you are an expert, you generally can't give opinion in court. So we saw Colin giving an opinion that the guy was a bank robber. That's an opinion. Colin's not an expert, and you heard the judge say, don't tell us what you think, just tell us what you saw. And that's all you're there to do as well, is to give evidence and present the facts as you saw and did certain things, not opinion. Now, there are some people who can give opinions, and we discussed this earlier, in earlier days. There are people who can give opinions, and they're expert witnesses. They've got to be classed as an expert by the court themselves, and there's a bit of a process involved with that. Speak clearly and slowly, and avoid jargon. Do not get up in the witness box and try and sound smart. It just doesn't work. People see through it. Be measured and calm. Now, it's easy for me to say this. When you get in the witness box, you'll be the opposite of those two things. Because everyone's looking at you, everyone's listening to what you say, and you may have some important things to say or not. It is hard to be calm. So your heart rate will be going a million miles an hour, but you just need to take a deep breath, listen to the question, pause, and then answer it. So you'll feel I can tell you what you will feel. You want to get in there and give this and get the hell out of there. Okay, and you want to do it as quickly as you possibly can. Some people, have a phobia about being watched and everybody watching them, and I get that. But you need to stop, listen to what you're being asked. That's the first thing. Pause, and then give your answer. All witness boxes have a glass of water, and normally a Corona thing of water. Use that. If you need a bit of time, nothing better than to fill your glass, have a bit of a sip, take the time you need. No judgment is cast on you about taking time to answer a question. And in fact, it's better that you do that. So think about the answer rather than just blurt it straight out. Any questions, Paul? No? Good. Clearly and slowly. Okay, this is about storing outcomes of proceedings. So at the end of proceedings, make notes. Well, you probably won't, but you might want to make a file note, which could go onto your relevant system. If you've got evidence, needs to go back to where you got it. Again, we give something back to someone, we always get a receipt. Always keep in mind appeals. Okay, so you may think the matter's over, and it may not. It could be going to a higher court, it could be appealed some other way. So this is sort of the reason we keep these documents for this 7 years and that sort of, thing. Okay. Okay, court. I'll talk a little bit about court etiquette and some related matters. This is something I've added in, Paul. Thank you. How to behave in court. Let's watch this. Maybe a duplication of what we've already seen. No? Oh.
How should I behave in court in Australia? Going to court can be daunting. Having an idea of what to expect will ensure that you are prepared and know how to behave appropriately. Courts are formal places, and certain rules of etiquette apply to anyone who enters, as is the case in any other formal setting, such as workplaces and educational facilities. You are expected to be respectful, and you must behave appropriately at all times. You may be asked by the magistrate or judge to leave the court if you dress or behave inappropriately. If your behaviour disrupts proceedings, you could also be fined or sent to jail. When going to court, make sure you are punctual and arrive before the scheduled time. You can find the correct courtroom by reading the notice boards and television screens at the courthouse, or by asking someone at the registry counter. They are usually located in the court's foyer. If your matter is being heard in a magistrate's or local court, wait outside the courtroom until you are called. In the district or county court, the bailiff will be able to tell you when your case will be heard. If you are going to the Supreme Court, you should wait inside the courtroom. Check with the bailiff to find out when your case is due to start. If you are being held in custody, corrections officers or police will make sure you are brought to the correct court at the appropriate time. They will show you where to sit. As you enter the courtroom, stand in the doorway and bow your head to the coat of arms behind the judge or magistrate as a sign of respect before finding your seat. Courts are busy places, so even once you have entered the courtroom, you may have to wait for a time until your matter is called. In this case, you should wait in the public seating area in the back until the court is ready to hear your case. When the court is ready for you, go to the centre table in the front of the courtroom. If you are represented, your lawyer will show you where to sit. You may represent yourself at court, but it is always advisable to seek legal advice first. Where you do not have a lawyer, if you are bringing the matter to court, you should sit on the right side of the table as you face the judge or magistrate. If you are defending the matter, you should sit on the left side of the table. The general rules of court etiquette apply throughout a court proceeding to everyone in the courtroom. Make sure you turn your mobile phone off, don't just switch it to silent. Turn off any alarms on your watch or any pages you have. Don't talk unless called upon to speak by the judge or magistrate. Do not eat, drink or chew gum. Do not smoke. Do not record or publish any of the proceedings. This includes postings to social media. The magistrate or judge is the boss of the courtroom. They sit at the front facing everyone else. Every person in the courtroom must behave respectfully towards the magistrate or judge by calling the magistrate or judge Your Honour, bowing their head to the magistrate or judge when entering or exiting the courtroom, standing and keeping quiet whenever the magistrate or judge enters or exits the courtroom, standing whenever the magistrate or judge addresses them, listening to and following any instructions given by the judge or magistrate. To show your respect in the courtroom, you will need to dress in a tidy, modest and smart manner. Conservative colours are best. Dress attire that may be suitable includes a suit, though this is not essential, a collared button-up shirt, make sure it is buttoned to an appropriate level, pants or a skirt at or below knee level, clean closed-in shoes. If you are representing yourself, it is recommended that you wear a jacket. Dress attire that is not suitable includes singlets, strapless or see-through tops, clothing with obscene, offensive or disrespectful slogans or graphics, jeans, thongs, short shorts, mini skirts, sunglasses, hats or caps. If you are dressed unsuitably, the judge or magistrate may reprimand you or ask you to leave. There is no specific legislation which prevents you from wearing forms of religious dress, such as turbans, skull caps, and burqas in the courtroom. However, some states now have legislation requiring you to remove head coverings if asked by police for identification purposes. Refusal to do so can result in a fine or imprisonment. Generally, the police will ensure that only female officers are present, and that it is only for a short period of time. Court etiquette in Queensland requires that, when leaving the courtroom, you again bow your head to the coat of arms behind the judge or magistrate as a sign of respect. If you are unclear about court etiquette in Australia, court staff will be able to assist. However, keep in mind that they are generally very busy, so it might be best to seek your information from organisations such as the Court Network. If you have a legal question, you should seek advice from a lawyer as soon as you can. Alternatively, the courts in each state and territory have a dedicated website which contains useful information about the magistrates or local court, the district or county court, and the Supreme Court, including details regarding court etiquette. You can also familiarise yourself with court etiquette and procedures by going to court and observing a proceeding before the commencement of your own. When doing so, sit in the public seating area at the back. You can find information about which matters are to be heard that day on the Daily Law Lists page of the court's websites. Not all cases are open to the public. You should check with the registry staff or the bailiff to make sure you can observe the proceedings. What to do next? If you or someone you know has to go to...
Okay, let's hope you don't. So that gives you a little bit of an idea about some of the etiquette, okay? Just to, I guess, I'm not sure where that video went over, but obviously up the back here is the judge, magistrate. Then in front of them is all sorts of different people. So they can be court transcribers. If it's a judge, it might be the judge's associate, there might be somebody else, etc., just in front. Then you've got what's called the bar table. Okay, so the bar table is where the lawyers sit. Then beyond that is the public gallery. So these will all be the same. Courthouses are generally all the same. What you've got to remember is that anywhere can be a court. This room we are in now can be convened as a court. That's not a problem, it gets set up. You go to some rural and regional courthouses and they've got these beautiful wooden old courthouses from, you know, the 1900s, and they're just magnificent. They creak and all sorts of stuff. And you go to a modern court, which is, you know, a modern room with TVs and stuff everywhere. So courts and tribunals are the same makeup generally, but different. So just remember, you can sit in the public gallery. You'll know where that is. Of course, if they close the court, they'll say anyone's not involved with the proceedings to leave, and you will. But just don't be apprehensive about going to court. It can be a little bit daunting, but you know, go there, have a look at the lists, what's on, and familiarise yourself with people coming in and out. If you've never been to court, what I will say to you is it is nothing like judge duty. Okay, so it is slow. It is excruciatingly, painfully slow. Sometimes you think, why don't these people hurry up? But it's just nothing like TV. And nothing like the American legal system either. So our Westminster system is very different. But you know, you'll get a good grasp on, you know, how it goes. You know, decisions that, you know, you see on TV, judges making decisions straight away and banging their gavel down. It just doesn't happen like that. You know, judges can go away for an hour, come back and make a decision. Judges can, in compact, go away for 6 months and come back and make a decision, which takes a month to read out. So it's very different to TV, like anything, but so is being a PI, as we know, is very different to TV as well. So if you're ever having, in the witness box, we've talked about being slow, being calm, drinking the water, thinking about what you say. You may be getting questions from a defence lawyer, which again, I reiterate to you, it sounds and feels to you like it's a personal attack. You just got to remember it's not personal, okay? Do not get into an argument in court. It just makes you look bad. Just answer the question. Sometimes you may be asked just yes or no, Mr. Smith, and you can't answer yes or no, or you want to explain. You still have to answer. You can't sit in the witness box and say, I'm not going to answer that. The judge will tell you to, okay? So answer the question, but say, look, the answer is yes, but I'd like to give an explanation and, you know, see what happens after that. Do not get into an argument. If you're going to give evidence, give it to the judge. The judge is the one hearing what you just say, or, you know, if you happen to have a jury, give your answers to the jury. Don't give your answers back to the person questioning you. Because this is what defence lawyers will do. They'll try and upset you, try and rattle you, but it's all about your credibility. If you enter into an argument with them and you want to, and tell you, if it's that bad, you'll want to jump out of that witness box and punch them in the face. But it doesn't look very good for you, does it though? So remain calm, don't get in an argument with them, just answer their questions and direct your answers to the relevant person. A couple of little tactics, there's hundreds, but these are some ones. And you know, if you're in court, you'll notice these people wandering around with their white wigs, flicking them around in their capes, like, you know, fussing around like they're Superman, and you know, all this sort of stuff with their glasses and trying to. It is a massive, big show. I can tell you that now. It's a massive show. Don't worry about that. Let it roll. Let the show roll in front of you. Have we seen this? Let's have a look at this video. Oh, it may be a repetition. Don't know whether it is.
Before you give evidence, it helps to know the role of everyone in court.
Yeah.
Everyone has an important part to play. The judge
so you'll see the layout there.
presides over the
This
court,
explains
and
what I
depending
just
on
said.
which court you are in, may wear a wig and gown. The judge's associate helps with case documents or exhibits. A court reporter or monitor keeps a record of exactly what is said in the course of the trial. The sheriff's officer is responsible for security in the court. The case may also be heard
They're
in
always
front of a
very
jury.
excited, those sheriff's
These are
officers.
12
Look at them.
members of the public who have been selected at random from the electoral roll. They won't know you or the accused. Their job is to hear all the evidence and decide beyond reasonable doubt if the person is guilty or not. In the middle of the courtroom is the bar table. This is where the Crown prosecutor and the defence team sit. The prosecution team is led by a barrister, known as a Crown prosecutor, and includes an instructing solicitor who will assist him or her. You are going to be in contact mainly with the prosecution team, who will do their best to help you feel comfortable on the day. The defence team may include a barrister as well as a solicitor who represents the accused. In the District and Supreme Courts, the barristers will usually wear wigs and gowns. The accused may sit behind the defence team, or they will sit in a special place in the court known as the dock. There are a number of different ways for you to give evidence in a court case. If you are a child under the age of 16, are cognitively impaired, or a victim of sexual assault, you may be able to use a screen in the courtroom or closed circuit television in a remote witness room to see what is going on in the courtroom. This is so you don't have to face the accused while you are giving your evidence. You will be able to see, hear and speak to the magistrate or judge and the prosecutor and defence lawyer. Everyone else in the court will be able to hear and see you too. Although you can be seen by all the people in the courtroom, remember that only the judge or magistrate or prosecutor and defence lawyer can talk to you. The magistrate or judge might ask you if you can see and hear them. Sometimes there can be problems with the equipment. If you can't see the magistrate or judge's face on the screen, just say so. If you can't hear what is being said clearly, let the judge know. If your statement was recorded beforehand on audio or videotape by the police, it too can be played in court.
Okay, just so a couple of more little things just to familiarise yourself if you're not. You've got to remember too, there's lots of different types of courts. Okay, what they're talking about here is a local magistrates court, which is the most common type, frankly. But you know, there are dozens and dozens of different courts. You know, industrial tribunals, civil courts. You know, things like coroner's court. So they're all courts as well. I mean, they all have different little idiosyncrasies, I suppose. And if you're ever involved in like a coroner's matter, which you may be as a PI, that it's still a court and it's still very formal. But you'll find you go to a coroner's court, the judge will ask you questions directly. Because it's more inquisitorial. Very interesting stuff though, I think so anyway. Okay, a couple of little tactics just to finish off on. Some tactics that you may find when you're sitting in the witness box. Rapid fire questioning is one. So they'll just ask a question after question after question really quickly. Why do they do that? Again, it's all a game. Okay, it's all to try and upset you and rattle you and make you seem like an uncredible witness. Okay, so don't worry too much about it. Just as I said, take your time, answer the question in the time that you need. Some defence solicitors, defence lawyers will be very overly friendly to you. So they might even come and see you before you go into the witness box and you'll think, oh, they're pretty good. Well, guess what? They're setting you up to what feels like an attack in court. So just be on the lookout for that. Don't worry too much about it. Glaring at a witness, look, that doesn't happen too much from lawyers and that, but it can. Again, it's supposed to rattle you. Don't worry too much about it. Remain calm. Things like mispronouncing your name. Again, it's a tactic. They'll deliberately do it. It's about getting you upset, so you'll, lose your calmness and maybe give an answer that doesn't help you or helps their client. Don't worry too much about it. Altering your words. So this does happen a bit. You will answer a question, then you might get a summation of that question from the lawyer back, which wasn't the same. Okay, you just need to respectfully acknowledge that that wasn't the same. No, that's not what I said, Your Honour, normally. And they'll pick up on that too. Demanding yes or no is a big one. So in court, it's very formal. They will say yes or no, Mr. Smith. Did you do this? Yes or no? And if you can't answer yes or no, you'll get very frustrated. You go, well, I can't answer. I'm not answering that, You've got to. The judge will tell you to. You just say that and clarify it with, look, the answer is yes, but there's an explanation that I'd like to give, Your Honour. And, you will or won't be allowed to. Repetitious questions. So the same question asked over and over again. It's just, again, you pretty well know if, a judge is going to say to you something like, I put it to you, Mr. Smith, that they're out of material. You just say, no, that's not true, or whatever. Highlighting inconsistent evidence. So this is important. This is their job to find inconsistencies. If you've made a statement in relation to a matter, it could be a motor vehicle or something, accident, and what you've said in court is different to what's in your statement, then there's maybe a problem. So hence, know your statement, okay? Staring you out, look, doesn't happen that often. Don't worry about it again. Don't play into it. That's my point. 2 questions in one can be a tactic as well. So double-barreled questions, okay? So just say, okay, thank you. I'll firstly answer the first question you had, then the second one, or which one do you want me to answer? Don't be a smart-ass though, because it's very easy to pick up a smart-ass when you're sitting in the witness box. This fellow is a barrister. He gives it's only a short video, he gives some really good tips on how to give evidence they may be relevant.
I'm Caleb Crossland and this is Law in 3 minutes. The do's and don'ts of giving evidence. Topic 1, credibility. The judge is studying you and assessing you when you give your evidence. So 3 things, simple. 1, be yourself, act naturally. 2, be polite. 3, don't be a smart aleck or argumentative. There's nothing worse than that for your credibility as a witness, and you're doing no favours to the party that's called you to give evidence. Topic 2, your written statement or brief of evidence. 4 things. Number 1, make sure that you are very familiar with your evidence. Practice by reading it aloud. Number 2, if your statement makes reference to other documents or exhibits, for example, make sure that you are also very familiar with those documents or exhibits. Number 3, and this will require some working in with the lawyer calling you as a witness, is please ensure that the language in your written statement is language that you would naturally use. And number 4, when you're questioned on your statement of evidence, try and ensure that the answers you give are consistent with what you have stated in your brief of evidence. Now the final topic for this video is cross-examination. There's 7 things that I'm going to talk about to assist you. The first point, very simple, is when you're listening to questions and answering, give your answers to the judge, look at the judge, don't look at opposing counsel over here. Tip 2, listen to the question, think about the question in your answer, and then give it. You have all the time in the world. Tip 3, make sure you answer the question actually asked of you. The biggest mistake that witnesses make is answering a different question. Here's an example. Did you go shopping on Friday? I went shopping on Thursday. Wrong answer. The correct answer is no, but I went shopping on Thursday. Even if the question is put in a way to you that suggests a yes or no answer, and you feel uncomfortable about that, still answer yes or no, but you are able to qualify that answer. Do not, for goodness sake, start launching into the excuse or the explanation that you think is important. Answer yes or no, then give your explanation. Tip 4, don't, for goodness sake, guess. The court is simply not interested in what you think might have happened. All the court is interested in is what you yourself remember witnessing. However, there may be ways that you can qualify an answer. For example, did you go shopping on Thursday? I don't remember, but it is my practice to shop every Thursday. Tip 5, look, opposing counsel is not the enemy. Be polite, don't be argumentative. Tip 6, if opposing counsel puts something to you like, are you saying Mr. or Ms. X is lying? Don't say yes. It's better to say something along these lines. I don't know whether they're lying or not. All I can tell you, counsel, is what I remember, and this is what I remember. Or, I don't know if they're lying. Really, that's a matter for the judge. Lastly, tip 7. Answer all questions as I have outlined above in this video, unless your counsel, who's called you as a witness, stands up and objects. If that happens, remain silent until the judge has made a ruling on the objection.
We're going to look at the assessments for the unit Greg just did on presenting evidence in court. Now, I know Greg said it's daunting. Yes, it is daunting, but it's so much fun as well. As I said when you saw me on the chat, I said I love it. I love it because all the attention's on me, and it's an interesting thing when you're in a court, especially with a jury, because you're trying to get the jury on your side. And I do a lot of eye contact when I go into court and I've got a jury sitting there. I'll look at the jury and just look at people individually and nod to them and do whatever. And it's about, as I said in the chat, it's about theatrics and looking at those people in the eye, get them on board. So I'll be chatting in the box, and I get to the point where I'm chatting and I'm looking at someone and they start nodding, like as I'm saying something, they're sort of nodding in agreements, because it's just about eye communication, body language, and you just contact. It's the same if you don't have a jury and you just got a magistrate. Well, you're looking at the magistrate and you're talking to the magistrate. So, and it's a very weird thing. A lot of people find it hard because you've got the prosecutor or the barrister, the defence barrister, asking you questions and looking at you, but you don't actually respond to them. You actually respond to, if you've got a jury, you talk to the jury. If there's no jury, you actually look at the magistrate and respond to the magistrate. So you've got questions coming from this person over here, but you're actually looking at the magistrate responding. So it takes a little bit of getting used to, but especially with the jury, because you've got trying to get 12 people on board, you look at them, make the eye contact. Got a couple of worries, but I won't tell them. Okay, let's look at the assessments. So, a couple of things with this. With the assessments, we've got the practical, the templates. Now, with the templates, what you're going to do is you're actually going to use, for one of the incidents, your office from 007, taking, I think it's your notes. You're going to use that example, and you can also use the video that you've used in that unit to upload into this unit. Plus, you need to create another video. A lot of people get confused with this. It's not rocket science, it's not brain surgery. It's a case of what I'm after is you standing in front of your camera, video camera, as giving evidence as you would in court. So you need to be dressed in the proper attire that you would for court. You need to say, "Thank you, Your Honour," as though you're standing there and you're addressing the Honour, and you say, "Thank you, Your Honour, my evidence is," and you give your evidence for what you've investigated, for whatever the scenario is that you've come up with. That's it. That's all I'm after. That you say, "Yes, on this date, I interviewed this person, they gave me this information, blah, blah, blah," and you go through, and I concluded my investigation with writing a report, and I now submit that report as evidence. It's only has to go for a couple of minutes. It's really not that big. That's all, and it's one of the videos that you do by yourself. You don't need another person to do this video. So that's what I'm after. With the template, you're just going through about the procedure, policies, procedures you just follow the bouncing ball of filling the templates out like all the others. This is an example you've got to do that of carrying out the procedures for court. So it's the template's more about preparing the evidence. Who did you speak to? How did you go about preparing your evidence? All that sort of stuff. So that's about preparing the evidence. It's a little bit of mock also. What happened at court? Did you have any issues? Whatever. But that's a combination of your template plus your video, so I can mark competent and not competent of delivering. It's the best way I can do this, other than turning up with you in court and watching you give evidence in court. It's the best I can do to mark you, assess you on being competent to give evidence in court. So that is the unit for giving evidence.